What you know, Alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Friday, December 19th. I just got the state's response to the appeal that Lori Daybell filed. The state's response was submitted just a couple of days ago, December 17th. This is going to have to be a few episodes because it is long. It is 68 pages. And if I try to upload anything past about 40 minutes, it will hang up and I have to start the process and it can take a while. And it makes me want to invent new curse words when that happens. So on this episode, we're essentially going to break down the first section of the filing. And that is really the basic facts of the case, covering the crimes and all of the different motions with attorneys, as well as Lori's competency. So just the backstory before we get into each section. Starts out, statement of the case and the nature of the case. Lori Noreen Vallow appeals from her judgment of conviction after a jury found her guilty of 2 counts of conspiracy to commit murder and grand theft, 2 counts of murder, 1 count of conspiracy to commit murder, and 1 count of grand theft. Statement of the facts and course of the proceedings. On February 20th, 2020, Lori Vallow was arrested in Hawaii and subsequently extradited to Idaho. The state charged Vallow with 2 counts of felony desertion of a child and several misdemeanor charges. The felony charges were for 2 of Vallow's minor children, Joshua J.J. Vallow and Tylee Ryan. Neither J.J. nor Tylee had been seen for several months. Attorney Mark Means was retained to represent Vallow sometime in late February or early March 2020. The representation was arranged and paid for by Vallow's husband, Chad Daybell. Means entered a notice of appearance as Vallow's counsel on March 4th, 2020. On March 21st, 2020, Chad Daybell retained John Pryor to represent him, though he had not yet been formally charged. Pryor's law office was in the same building complex as Means' law office, but Pryor and Means did not work for the same law firm. Daybell also retained Means as his own attorney. On April 28, 2020, Means made public representations that he represented Daybell. Means posted the following on Twitter. Please note that this office represents Mr. Chad Daybell. If any agency, investigative authority, etc. wishes to contact my client, please contact my office directly. Means also sent a press release to the media stating, please take notice that this office represents Mr. Chad Daybell. Please direct all requests for communications/statements of the like to this office. Means also emailed the prosecutor on Vallow's case asking him to provide a press release stating that Mr. Means represented Chad Daybell and to direct investigation efforts relating to Daybell or Vallow to him. On the same day, April 28, 2020, Daybell expressly stated that Means was his attorney. In a jail communication with Vallow, Daybell stated, Mark Means is my attorney. Daybell alluded he had shared confidential information with Mr. Means that Daybell believed would be covered by attorney-client privilege. Daybell even suggested that he believed he would not have to testify against Vallow if Mr. Means represented them both. Daybell also stated he was eventually going with the other guy, referring to Mr. Pryor. 2 days later, on May 2, 2020, Vallow appeared in court for a bail reduction hearing. Means appeared on Vallow's behalf and told the court he represented both Vallow and Daybell. On June 9, 2020, law enforcement executed a search warrant on Daybell's property searching for JJ and Tylee or evidence of their disappearance. Daybell was present and observed the search. During the search, Daybell called Mr. Means before calling Mr. Pryor. Law enforcement found JJ's body and Tylee's remains on Daybell's property. After the execution of the search warrant, the state charged both Vallow and Daybell with the destruction of evidence and conspiracy to destroy evidence. The state named Daybell as a co-conspirator in Vallow's case and Vallow as a co-conspirator in Daybell's case. Vallow's initial appearance in the new case occurred on June 30th, 2020. The court asked Means whether he had ever represented any co-conspirator in the complaint and, despite his previous public statements to the contrary, Means told the court he had not. The prosecutor insisted that Means had a conflict. The court requested briefing on the issue. The state and Means filed briefs addressing the conflict issue. The court then held a sealed hearing on the matter on July 20th, 2020. Means now took the position contrary to what he previously told the court that a limited representation had occurred between him and Daybell, but it did not create a conflict. He said, "Our position is that there was limited representation, that there was not an opportunity for conflict, and that a conflict had not occurred, and the analysis should end there." On July 31st, 2020, the court issued its ruling. The court held a conflict of interest exists in this case, but it is not an actual conflict that would currently rise to Mr. Means' disqualification from representing Vallow. The court thus allowed Vallow to waive the conflict and continue with Means as their attorney. The court emphasized, however, that it would not have allowed the conflict to be waived if the charges carried a heavier punishment. The court notes that this decision coincides with the current charges against the defendants. If the charges carried maximum penalties of life imprisonment and/or the death penalty, the court would be more inclined to find actual conflict and not honor the waiver. Means provided the court with a waiver purporting to waive the conflict created by Means, representing both Vallow and Daybell on substantially related matters. The waiver was signed by Vallow and Daybell, dated March 31st, 2020. On March 2nd, 2021, Means filed a request for Vallow to be evaluated for competency to stand trial. Then, on April 30th, 2021, Dr. John E. Landers issued a report concluding Vallow was incompetent to proceed to trial. Means did not contest the finding that Vallow was not competent, but did seek and obtain an order from the court declaring Vallow indigent such that the county had to pay for the examination. The state initially challenged the incompetency determination, but withdrew the challenge. The court found Vallow incompetent to stand trial on June 9th, 2021. On May 24th, 2021, after Dr. Landers issued his report finding Vallow incompetent, a Fremont County grand jury returned an indictment charging Daybell and Vallow as co-conspirators in the deaths of Tylee, JJ, and Chad's deceased wife, Tamara Tammy Daybell. Specifically, Vallow was charged with 2 counts of first-degree murder, 2 counts of conspiracy to commit first-degree murder and grand theft, and 1 count of conspiracy to commit first-degree murder. The grand jury indictment spawned 2 additional criminal cases in the Daybell-Vallow saga. Despite the indictment naming and charging Vallow and Daybell as co-defendants and co-conspirators in the same indictment, 2 separate cases were opened, one for Daybell and a separate case for Vallow. The Vallow 1624 case is the case from which Vallow appeals in this matter. On May 27, 2021, 3 days after the grand jury indicted Vallow and Daybell, the district court entered an order staying Vallow's case because of the issue of defendant's competency that had arisen. Means filed a notice of appearance that same day claiming to represent Vallow in the new death penalty eligible case. On June 9th, 2021, the district court entered an order finding Vallow was not competent to proceed and suspended the case except as provided in Idaho Code. Because the district court treated the single grand jury indictment as the start of 2 separate cases, only Vallow's case was suspended, and Daybell's case was allowed to proceed. This was true even though, at the time, the plan was for the 2 cases to go to trial together. To further complicate the matter, the parties and the district court continued filing into the purportedly suspended Vallow case while Vallow remained incompetent to proceed to trial. Means, for example, filed a motion to compel a declaration in support of his motion to compel reservation of substantive and procedural rights, a motion to change the venue of the trial, and more, all while his client was still incompetent and the case was at least purportedly suspended. In that same time frame, the state filed on June 27, 2021, a motion to disqualify Means as Vallow's attorney. The state filed the motion in both Vallow's case and Daybell's case. The motion argued that Means had a conflict from representing both Vallow and Daybell, with respect to the facts underlying the alleged murders, that the nature of the conflict meant that it could not be waived and that the district court should disqualify Means from all future proceedings relating to the alleged crimes. On August 6, 2021, the district court entered an order requiring the appointment of a death penalty qualified public defender to represent Vallow as co-counsel with Means. The district court explained that it entered the order in response to the state's motion to disqualify Means and to protect Vallow's constitutional rights. James Archibald was appointed as co-counsel to represent Vallow. Means did not file a response to the state's motion to disqualify him as Vallow's counsel. Instead, he chose to put his efforts into trying to intervene in Daybell's case to fight the state's allegations of a conflict. But the district court refused to allow Means to intervene in a separate criminal case, observing that no rule allowed for such intervention. The district court also made clear in all the proceedings related to the conflict in the Daybell case that the hearings were limited to the Daybell case and did not include the Vallow case. On December 28, 2021, after still having not received a response to the conflict allegations in the Vallow case from Means, the district court entered an order disqualifying Means from the case. The district court found, as did the magistrate court before it, that an actual conflict existed because Means had represented both Daybell and Vallow with respect to a common set of facts. The district court also explained, consistent with the magistrate court's reasoning, that the district court would not allow waiver of the conflict in this case because of the seriousness of the charges Vallow faced. In addition to the conflict, the district court also cited its lack of confidence in Means' ability to represent Vallow in a death penalty case. Finally, the district court explained that it had to act prior to Vallow being restored to competency because of the regularity with which pleadings continued to be filed by the parties. The district court thus ordered that Means was disqualified from representing Vallow in the immediate case and all matters substantially related thereto. The district court appointed Archibald to represent Vallow as lead counsel. On April 11, 2022, the district court found Vallow had been restored to competency and was fit to proceed to trial. It lifted the stay in the case and ordered she be brought before the court for the arraignment. Vallow was then arraigned on April 19, 2022. The next day, the district court set the trial for 10 weeks, starting on October 11, 2022. On May 5, 2022, the state moved to continue the trial to January 9, 2023. The state argued that Vallow and Daybell should be tried together, and Daybell's trial had already been set for January 9th. The district court granted the continuance. It found the length of the delay reasonable given the complexity and seriousness of the case and the short length of the delay requested. And they quote, 82 days beyond the deadline of October 19, 2022, for purposes of evaluating defendant's statutory right to a speedy trial, end quote. The district court also found the reason for the delay supported the continuance, given the need to avoid improper severance of the Daybell and Vallow trial and to give both sides time to prepare for trial. It also acknowledged that Vallow had unequivocally asserted her right to a speedy trial, but that the delay would not prejudice her because it would give her team additional time to prepare. Thus, the trial court moved the date of the trial from October 11, 2022 to January 9, 2023. On September 30, 2022, prior to the original trial date, defense counsel filed a motion seeking to continue the trial and stay the case. The motion stated that the defense wanted to continue the trial date so they could once again address the defendant's mental health. Attached to the motion was an affidavit from defense counsel explaining that 3 of their own mental health experts all agreed that Vallow was not competent to stand trial. The motion asked to continue the trial so that Vallow could receive restorative treatment. Attached to the affidavit was a report from a board-certified clinical psychologist who had concluded Vallow was not competent to stand trial. On October 6, 2022, and in response to the defense's motion and expert report, the district court set a competency hearing pursuant to Idaho Code. The district court also stayed the case until such time as the court renders a final decision regarding the defendant's competency to stand trial following a contested competency hearing. The district court held a competency hearing on November 9, 2022, and then issued a written decision on November 15, 2022, finding Vallow competent to stand trial. The order also lifted the stay imposed on October 6, 2022. The January 9, 2023 trial date was also vacated due to the defense's motion. In December 2022, The district court held a scheduling conference to discuss a new date for the trial. Daybell's counsel requested a trial date no sooner than October 2024. The state proposed a late summer 2023 start date, and Vallo's counsel insisted upon a date no later than February 21st, 2023. However, to give the parties time to complete discovery and for the court to arrange for trial in Ada County, where it had been moved in response to Vallo's motion to change venue, the district court set the date for April 3rd, 2023. After the district court set the new trial date, Vallo moved to dismiss the case on the basis that the new trial date violated her rights to a speedy trial. The district court denied the motion. On January 27, 2023, the state provided notice under Rule 404B of the Idaho Rules of Evidence that it intended to introduce at trial evidence that fit into 25 different categories. The defense objected, arguing the state had not provided sufficient notice of the facts it intended to introduce and that it had not provided reasonable notice prior to trial. At a hearing on February 9, 2023, the district court requested the state narrow their scope when looking at 404B. That's prior bad acts. On February 14, 2023, the state filed an amended notice for the introduction of evidence pursuant to Rule 404B. This time, rather than list out categories of evidence, the state provided an overview of proposed evidence in narrative format. The state's notice proffered the evidence it had to show how Daybell, Vallo, and their group operated. Their group included Zulema, Melanie Gibb, and Alex Cox, who was Vallo's brother. As the group's de facto leader, Daybell could determine if someone was light or dark and if someone had a dark entity. Once Daybell made the determination that someone was dark, he would inform Vallo and the others in their group that the person's body was possessed by a dark entity/spirit, which would then require their body to be destroyed/killed. Another feature of this group was that Daybell had designated Alex as a protector for Vallo. Daybell had informed Vallo and Alex that Alex was here in this creation or current probationary period on Earth to protect Vallo. Multiple witnesses had also established that Alex would do whatever Daybell asked him to do. The state proposed 404B evidence showed how this group operated on 2 occasions, prior to the murders in Idaho. The proposed evidence first covered the murder of Charles Vallo in Arizona. Charles was Vallo's husband at the time he was killed. Prior to Charles's murder, Daybell had pronounced that Charles was dark. Vallo had been telling individuals that Charles was no longer himself, and both Vallo and Daybell were informing people that Charles's spirit was no longer in his body and that his body was instead inhabited by an evil spirit/entity. On June 11, 2019, Charles arrived home to find Vallo and Alex there. Vallo and Alex claimed there was some sort of a dispute, which resulted in Charles obtaining a bat and Alex shooting him. Vallo provided to law enforcement the outlandish story that she heard the shot, went back in and saw Charles on the floor, then left the residence to take her son to school. She went to Burger King, took her son to school, went to a CVS, and then returned to her residence where law enforcement was already on scene. For his part, Alex stated after he shot Charles, he washed his hands, put the gun away, and called 911. Alex claimed it was self-defense, but law enforcement could show that one of the 2 bullets that shot Charles was fired after Charles was on the floor, that Alex claimed he tried to provide CPR even though there was no indication CPR had been attempted, and that Alex had not called 911 for 43 minutes after the shooting. The state also had evidence that prior to Charles's murder, Vallo had taken $35,000 out of his business account and that Vallo believed she was the recipient of Charles's $1 million life insurance policy. The proposed evidence also covered the attempted shooting of Brandon Boudreaux on October 2, 2019. The state had evidence showing that prior to the shooting, Daybell had determined Brandon was a dark spirit/entity, and he requested that Alex kill him. The investigation into the attempted shooting led law enforcement straight to Alex. And, like with Charles, a member of the Daybell Vallo group, Melanice stood to benefit from Brandon's death as Brandon had a life insurance policy. The state also had evidence showing Melanice provided financial resources to both Vallow and Alex. The district court held a hearing on the state's amended 404B notice on February 16, 2023. The district court overruled the defendant's objections to the 404B evidence with a couple of exceptions. First, the district court excluded evidence of Vallow taking $35,000 from Charles, finding it would be more prejudicial than probative because Vallow was married to Charles at the time and Arizona was a community property state. Second, the district court excluded any reference to the past criminal case against Vallow in Madison County because the state had dismissed it with prejudice. But the district did overrule the objection as to the allegations underlying the criminal case. A jury convicted Vallow on all counts at trial, and the district court sentenced her to a unified sentence of life imprisonment without the possibility of parole. This appeal followed. So the last part we're going to talk about before we end this episode are the issues that will be discussed in the state's response. It says, Vallow states the issues on appeal as 1. Lori Daybell was deprived of her Sixth Amendment right to counsel of her choice when the district court disqualified her retained attorney. 2. Ms. Daybell was deprived of her Sixth Amendment right to the assistance of counsel during pretrial hearings on the state's motion to disqualify her counsel after the district court denied her attorney's request to participate in those hearings. 3. Ms. Daybell was deprived of her right to due process under the 14th Amendment when the district court held pretrial hearings that affected her substantial rights in her absence and while she was incompetent. 4. The district court erred in allowing state to introduce evidence of uncharged bad acts from Arizona into the Idaho criminal trial under Rule 404B of the Idaho Rules of Evidence. 5. The district court erred in denying Ms. Daybell's motion to dismiss based on violation of her statutory and constitutional rights to a speedy trial. The state rephrases the issues as 1. Has Vallow failed to show the district court violated her Sixth Amendment right to counsel of her choice by disqualifying her attorney? 2. Has Vallow failed to show the district court committed fundamental error by violating her Sixth Amendment right to the assistance of counsel? 3. Has Vallow failed to show the district court committed fundamental error by violating her due process right not to be prosecuted or to be physically present at proceedings? 4. Has Vallow failed to show the district court erred by overruling Vallow's pretrial objection to the state's proposed 404B evidence? And 5. Has Vallow failed to show the district court erred when it denied her motion to dismiss on the basis that her speedy trial rights were violated? So those are the things the state is going to pick apart and make their argument. And we will continue this in another episode. I do have to get ready around 5. My son is having a big Christmas party at the fire station he works at with all of his coworkers and their family. So I'm going to head that way and enjoy the evening with my son and his coworkers who are amazing people. So hopefully I can get one more in today and then I'll put out some more over the weekend. But that's it for now. Hope you guys have a good rest of your afternoon and we will see you soon.